Okay.
All right. Now, Officer Dave.
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Hello?
Good morning. We are on the record calling file number 04-125736, CFC Financial versus Valerie Shelton. This matter is scheduled for hearing today at 10 o'clock for an objection to garnishment. It's currently 10:30. What is your name, ma'am?
Valerie Shelton?
All right. When you filed your objection to garnishment, did you serve notice on this on the other side?
What do you mean, serve notice?
Notice up to the other side of the hearing of your motion.
Well, you mean the one that you mailed back to me?
Did you send one to the other side? Yes, ma'am.
I mailed in what I mailed in and I got a copy of it.
All right. We're going to go proceed, ma'am, but it sounds as if you failed to notify the other side, but let's move forward. You are the moving party. You have the burden of persuasion. What is the basis, ma'am, of your objection to garnishment?
First of all, I don't even know who these people are that I owe money to.
Do you have any other basis for that other than you don't know who they are?
Currently, I have a health condition and I feel like that the situation with the people that are trying to take money from me is hindering me and upsetting my stomach.
All right. Do you have any other basis for your objection to garnishment?
None that I can think of right now.
Then let me move forward here. Your stated basis are that the creditor is unknown and has not made contact until now.
Yeah.
This judgment was entered against you, ma'am, in December 2nd of 2004 and was renewed on November 25 of 2014. In the pleading that where the other side renewed the judgment, they indicated that they had received a payment in the amount of $141 on August 11th of 2014, which was the last payment received. So at least at one point in time, you had made some apparently payment to them. More importantly, ma'am, you may not use as the objection to garnishment under Michigan Court Rule 3.101K. You cannot use the objection to garnishment to challenge the basis of the underlying judgment. And that's what you're attempting to do here. So the court is going to have to deny your objection to garnishment. You, of course, have an absolute right to appeal my decision. That appeal has to be perfected within 21 days of today in the Wayne County Circuit Court. While I understand your position that you are having health problems are not a legal basis for an objection to garnishment. Your objection to garnishment will therefore be denied. And again, you have 21 days to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you for coming in, ma'am. We'll send you out an order today.
Can I ask a question?
Ma'am?
Can I obtain a lawyer because I don't want to
Yes, ma'am.
say things that may incriminate myself?
Okay, first of all, this is a civil matter, not a criminal matter. So if you want to hire a lawyer, you certainly have a right to do that. But the state does not provide lawyers in civil cases, only in criminal cases.
Okay.
Thank you, ma'am. We're off the record.
Thank you.
Have a good day. All right, good morning. All right, Ms. Dillon, what brings you to my court today?
Your Honor, Discover Bank on 00.
Krista Montgomery, is that it?
Yes,
Okay. And I think you're Krista Montgomery, ma'am? Okay, I think I have both of you. So let me get you into the waiting room, then we'll get started up and get everybody else checked in. So you go into the waiting room. Ms. Montgomery is going to the waiting room. All right, Mr. Eckleberry, why are you here today?
I'm here on Kira Wright, Your Honor.
Kira Wright versus Nemec.
Nemec, correct?
Okay. And Ms. Sheehan, why are you here today?
Your Honor, I'm here for the city of Detroit in the Northwest Labs matter.
Okay. So neither of you are. So away you go. Waiting room, I'll get to you as soon as I got somebody.
Good morning, Your Honor.
Mr. DeCruz, what brings you here today?
I'm on that Northwest Labs matter, Your Honor.
Okay. I got one ahead of you.
No problem, Your Honor.
Off to the waiting room for you.
See you soon.
All right. We are on the record calling file number 11-02008. The file is entitled Discover Bank versus Kristen Montgomery. Your respective appearances.
Jennifer Dillo, P69855, appearing on behalf of the plaintiff.
And what is your name, ma'am? What is your name, ma'am? Are you Kristen Montgomery? Ms. Montgomery, are you here? I see your lips moving, ma'am. I'm not hearing you. Ms. Montgomery? Ms. Montgomery? I see her face, but I don't hear her. Ms. Montgomery, unmute yourself. Ms. Dillo, I'm not getting anywhere with this. I'm putting her in the waiting room and I have to come back to you.
Okay.
That was wrong. All right, the next file is which one? The Krug 544. All right, Ms. Sheehan, I have you. And a minute ago, I had Mr. DeCruz. I don't seem to see him now. There he is. Okay, I seem to have both sides now. Let's call case number 20164-544, Northwest Labs versus City of Detroit. May I have your respective appearances?
Good morning, Your Honor. Joe DeCruz, P84445, on behalf of the plaintiff.
Good morning, Your Honor. Laura Sheehan, P83327, on behalf of the city of Detroit defendant.
Okay. This is the date and time for pretrial. And since we were last together, City of Detroit filed a motion for summary disposition, saying in essence, if there's an assignment here, it's a void assignment because we had previously paid and gotten satisfaction from the other guy. So I guess we really aren't going to be able to do too much today other than set that for hearing, unless you guys want to resolve it today.
Your Honor, I don't have that MSD. If there's something that I'm missing, I would love to see it, and maybe we can resolve it prior to you hearing it.
Well, it was filed here, Mr. DeCruz, it looks like March 4.
Yeah, I do not believe I have it, Your Honor. But then again, I have Gregory Pattison on this case, so I don't know why that is either. On our initial disclosures, we have the City of Detroit and Gregory on here, so
Well,
sure.
I'll just give you guys a date. 'Cause
Your Honor, just a real quick question. The motion that we filed should have been for the 1-year back rule. I'm wondering if the things got switched.
is this, I'm reading your, yep, you're correct. Yours is a 1-year back rule.
Okay.
There's another city case where the claim was the assignment, yeah. But in either event, Mr. DeCruz doesn't have it.
Right,
So we
absolutely.
had just said it for here. But their proof of service, Mr. DeCruz indicates that you were served and that, so, but I think there's something wrong with this proof of service, Ms. Sheehan, because it says you served it on January 29th. And the motion was filed here. It looks like March the 4th. And that was after we had a pretrial on February the 2nd. And there was no mention of that motion. So you might want to make sure you send out another copy and file a correct proof of service here. January 29th is.
That was the day the answer was filed, so I'm wondering if my paralegal just switched.
Well,
Just
you know,
switched
the
stuff,
thing
yeah.
is, last time I looked at the rule, and it's admittedly been a while, my recollection was it was a signature of the lawyer, not the paralegal.
Right.
Did I misrecall that?
Nope, you're correct, Your Honor.
I thought there was some things that a signature of a lawyer was supposed to mean.
Yes.
I'm just, you know, it's been a while since I looked at that.
Nope, and I'm
I would-
responsible for all her actions. You're absolutely correct, Your Honor.
I would prefer not to have to read it.
Yes.
Because if I
No problem.
read it, my recollection is sanctions shall be imposed for violation.
Well,
So I would prefer not to read it.
Yes, Your Honor.
Yes, sir. I believe it was just a simple mix-up, Your Honor. Laura, if you can please, you can serve me via email. Just send it directly to my email.
So I have Miss Bossy listed. I don't have you listed. Can you want to do it off the record? I can call you and get your email, or if you just want to give it to me here, it's up to you.
It's jd@atlawgroup.com.
All right.
No dash or anything, like just AT Law Group? Okay.
Yep, same as Miss Bez, just JD in the front.
Okay.
Okay.
And Your Honor, do you want us to file a corrected proof of service, or do you want us to refile the whole motion just to make it clear for the record?
Corrected proof of service. What I'm going to do today is to give you an assigned date for the motion. We'll set up a hearing May 5. Does that work for everybody?
Yes, Your Honor.
How about you, Richard DeCruz?
1 second, Your Honor. I will tell you. Your Honor, what time on May 5th?
11 o'clock like today.
Your Honor, that would be wonderful to see you again on Wednesday, May 5th at 11.
5/2021 at 11 a.m. You will hear defendant's motion for summary disposition. You will serve Mr. DeCruz again. You will file a corrected proof of service.
Yes, Your Honor.
Anything else?
No, Your Honor, thank you very much. It was nice seeing you.
Good to see you. May 5 at 11 o'clock. Thank you both for coming in. We are off the record.
Thank you.
Thank you,
Laura,
Your Honor.
send me an email, Laura.
Yeah, I'll do that right now.
All right. Good morning, gentlemen.
Good morning, Your Honor.
Your Honor.
I think this is Sierra Wright versus Mimic.
That's correct.
Okay. We are on the record calling case number 20163-587. Sierra Wright versus Mimic Insurance. Date and time for pretrial. Your respective appearances.
Morning, Your Honor. James Eckleberry, P78222, appearing on behalf of plaintiff Kira Wright.
Good morning, Your Honor. Brian Robillard, P63090, appearing on behalf of defendant.
All right, gentlemen, where are we on resolution on this thing?
We're getting closer, Your Honor. We were emailing on Monday. The last time we were in front of you, we discussed the coordinated nature of the insurance policy.
Right?
Mr. Eckleberry did submit the bills to the health insurer. I now have to pass those along to my adjuster with a tidy report. The demand is about 2,800 or so. Is that right?
25, yep.
2,500. So, Your Honor, it's a very small case. I think we could resolve it. I just need to get the authority. I'm going to recommend pretty much what was demanded and see what happens.
Right.
And so I expect to have that report to my adjuster by the end of the week. And Mimic normally is very responsive. So I hope to have some news maybe next week or at least in 2 weeks to hopefully get this one wrapped up.
And how about I have you guys come back May 5? That'll give you enough time, if you're in fact able to kill it, to send in the closing documents, and I won't even have to see your faces again. I mean, I don't mind seeing your faces,
But they're so pretty.
but I'm trying to use your time effectively.
I think, Your Honor, I think that's
mine. So, you know,
I think that's plenty of time, Your Honor. I have to tell you just briefly, Your Honor, the last time I had a case in front of you was probably 10 years ago or so, and I had a newborn. That daughter is now 11, and I have added a second one since then. So
wow, Tempest future. I guess the alternatives are one gets old or one doesn't, and doesn't get old is kind of unpleasant.
yes. And
Let's work on getting older.
Yeah, I'm doing virtual school with both of them. I've done helped my oldest with a very nice report on the Aztecs the last 3 days. So
Outstanding. I hope your family as well.
yes.
Gentlemen, let's get this one done. Mr. Eckleberry, does that day work for you?
Would Your Honor give us the 10 o'clock call on May 5th?
You want the 10 o'clock call? Does that work for you, Mr. Robles?
That will, Your Honor.
May 10th, May 5th, you want the 10 o'clock call?
Yes, please.
I can do
Correct.
it. All right, then May 5, 2021 at 10 a.m. will be our next pretrial. Let's get this thing done, gentlemen.
Thank you, Your Honor.
Your Honor, thank you.
Have a great
I'll be in touch. Thank you.
for coming in.
Thank you.
Be safe.
You too.
As well, Your Honor.
We're off.
Bye.
All right, this is case number 20156-639, Affiliated Diagnostics versus City of Detroit. Your respective appearances.
Good morning, Your Honor. James Lowe on behalf of the plaintiff.
Bar number.
P63110.
And good morning, Your Honor. Sarah Delvin, P79128 on behalf of defendant.
All right, we are here today for a motion for summary disposition filed on behalf of the defendant, City of Detroit. We have a motion filed by the city. We have a response to the motion filed by the plaintiff in the file. Ms. Dolman, I believe it is your motion,
Yes, Your Honor.
if you would.
Yes, Your Honor, I'm basically just going to respond to the arguments in plaintiff's response because I know the court has our motion and has read it. So the main argument that they address is whether the language was conspicuous on the face of the check. The court has seen the check. It was attached to our motion. And the accord and satisfaction language is printed on the face of the check. And plaintiff basically argues that the font was not in bold or all caps or bigger than the other things that were printed on the check. However, I mean, there aren't that many places that the language could have been put on the check. It was printed on the front of the check in different font from the rest of the language on the check in approximately the same size font. So if plaintiff were to have looked over the check to see what the amount was, or to make sure it was written out to the proper provider, then they certainly would have seen the accord and satisfaction language. I don't think that it's so small that one would have to really hunt around to find it. I think if someone received that check and looked at the face of it, it would have been pretty obvious that that language was on it. And
Just so the record is clear.
yes, Your Honor.
I'm sorry, go ahead. Please continue.
Okay. And then whether or not the plaintiff knew that that language was there, I think again, if they had looked at the check before signing it, they would have seen that language. Further, when the provider signed the check, they didn't put any language such as under protest to indicate that they did not agree with the amount. If they received a check for $3,000, I don't think that there's any reason that they would have expected that they were going to get another check for more money later. So if $3,000 wasn't sufficient, then they should not have cashed this check, especially given the accord and satisfaction language. And finally, plaintiff has not pointed to any evidence that there was bad faith on the part of defendant in issuing the check in this amount. They didn't necessarily argue that, but they did point out that that was one of the factors in this analysis, whether the payment was made in good faith. And I think in this case, the defendant did make the payment in good faith. The review was explained in the explanation of review that was also sent to plaintiff. And an insurer is entitled to review bills for the usual and customary amount and determine what is a reasonable and customary amount to pay for those services. And finally, I don't think this was attached to the motion, but it was sent to us, so it may have been sent to the court as well, which is that plaintiff attached an order from another judge denying a motion for summary disposition, presumably for the same type of argument. And defendant would just argue that this is not relevant because what other judges have done to this type of argument isn't relevant in this particular case, and that the city has had the same motion granted in other cases, and apparently plaintiff has had the motion denied. So given that history, I would think it would be up to each individual judge what they were going to do with this motion.
Well, as I understand, let me hear from the plaintiff in this matter.
Sure, certainly, Your Honor. So there are a few things. First, as with respect to the statement that's on the check, it's already been mentioned, and defense has argued about the statement itself. But the statement in smaller letters says, "Paid in full in accord and satisfaction for services referenced on the stub." I don't see where the stub was attached as any exhibit, and that language in itself makes the statement confusing. There's no stub attached as an exhibit to the motion or anything there. So that in and of itself, who knows what services, who knows what patient, that the patient isn't even referenced on the check. So I think that in and of itself makes it not a conspicuous statement under the Michigan UCC, but the Michigan UCC has requirements about the font being larger or being in bold or being in a different color, etc. And those statements are not met as well. With respect to the first prong, it's not whether the payment was made in good faith, it's whether the payment was, that the defendant can prove that the check was sent with the intent that it be in full accord and satisfaction. This looks like this statement is printed on every single check that comes out of this account, which would mean that they're not paying these in good faith with the intent that they are in full accord and satisfaction of the amount.
I don't understand that argument. If I get a bill and I send in a negotiated amount on that bill, is your position that per se means it is not in good faith if I write that on every check?
Well, they have to prove that they intended this check to be in full accord and satisfaction of the debt. That has separate elements than just tendering a payment.
What about the plain language on the face of the check?
It says
their intent.
It says for services referenced on stub. There's no stub here. It's referencing a different document, and that different document's not attached as an exhibit.
Okay. Anything else?
Yes, and they, as part of the elements of accord and satisfaction, they have to prove that my client knew that this check was intended as accord and satisfaction. When the council brings up the statement under protest, the statement under protest hasn't existed as a defense in Michigan for accord and satisfaction for 50 years. But they haven't proven that my client knew that this was intended as a special circumstance of accord and satisfaction, whereas if you cash the check, you cannot go after the remaining balance. As we know in these PIP provider cases, the issue of reasonableness of charge is normally for the jury. They haven't been able to show through deposition or anything else that my client knew that it was intended as this special circumstance.
Okay. Anything else you want to hear me, Ms. Dolman?
Yes, Your Honor, just in regards to the stub, it was provided to the plaintiff with the check. We couldn't locate it at the time of this motion, which is why we attached the explanation of review, because it refers to the same services that would have been printed on the stub. So it actually has the procedure codes, the amounts that were billed, and then the amounts that were allowed.
But this is a 2.116C10 motion. We have to take all the facts in the light most favorable to the non-moving party. And here we're making an assumption. Under a 2.116C10 motion, we can't make assumptions that favor the defendant because defendant's asking the court as a matter of law to make a decision. Any assumptions that's made has to be made in favor of the non-moving party, which is my client. This references a stub and the stub is not attached.
All right, thank you. I'm prepared to rule. I'm going to grant the motion for summary disposition. There's been a cogent explanation as to why the sub was not presently attached, but that the routine practice was, and indeed you were provided with a copy of it. The face of the document indicates it's intended to be, from the city's perspective, full final resolution of those claims. The motion for summary disposition is granted, court finding there to be no genuine issue of material fact. You of course have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. Court will send you guys out an order today, and thank you both for coming in and thank you for your arguments. You're off to
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day, both of you.
You too.
We are on the record calling again 1110208. Discover Bank versus Krista Montgomery, your respective appearances.
Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
I still cannot hear the court's audio. Is the court able to hear me?
I hear you now. When you lean forward, I hear you. Ms. Dillow, are you having any trouble hearing me?
No, I can hear.
What's your name, ma'am?
If the court can hear me, can you please raise your hand? Okay, I cannot hear the court.
I hear you. Okay, then I'm going to move forward on this.
I'm going to do the dial-in. I'm going to call the court and do the dial-in Zoom hearing because I cannot hear any audio through this process.
I will wait for 5 minutes, ma'am, and then I'm going to proceed.
I cannot hear anything that the court is saying.
Let me write something down. Can you read what I'm saying? I will wait
Thank you, Your Honor. I will call in.
5 more minutes. All right, then what I'll do is I'll release you here and we'll wait for you to call back in on the Zoom. Okay, Ms. Dillow, you're going back to the waiting room. Ms. Montgomery, I'm releasing you now. Ms. Montgomery, are you there?
Yes.
All right, we are on the record calling file number 11102008, Discover Bank versus Krista Montgomery. There are a number of matters before the court today. The first matter we're going to handle is a objection filed to a 7-day order. We were last together on this file on March 5, 2021. At that time, the court denied all of the defendant's motions for the reasons set forth on the record. Counsel for plaintiff was to submit a 7-day order. That 7-day order was submitted, and then under MCR 2.602B, an objection was filed. This is the hearing on that objection. Ms. Montgomery, what is the basis of your objection to the proposed 7-day order?
There were a few clerical errors. The plaintiff's counsel did state that they did not have any objection to the correction of the errors that I noted, and they did submit the order that I provided.
Ms. Dillow?
Yes, Your Honor. We believe that the order we submitted accurately reflected the court's ruling. However, the defendant's proposed changes are merely as to form. So there's no objection to the court entering the defendant's proposed order.
All right, so now resolve that issue. We'll enter the defendant's proposed order. Now resolve the 2.602B matter. We also have before us today defendant's motion for the court to respond to records requests and motion to extend time for filing. The response has been filed to that by Ms. Dillow. Ms. Montgomery, your motions.
Yes, Your Honor. The file for this case has been kept in the courtroom instead of being returned to the records department. So as a result, the records department has not been able to address my records request. In addition to that, as you know, the court is currently closed to the public due to the COVID-19 pandemic. Therefore, I've made the request directly to your courtroom where the file is being held. On January 26, 2021, the plaintiff filed an ex parte motion in order to renew civil judgment. My request is to know how many pages were filed with the court. This includes any briefs, attachments, exhibits, proof of service, etc., and the cost for a copy of all pages filed with the court. And in regards to the motion for the court to extend time for filing, that was in regards to the motion for reconsideration. On March 25th, 2021, prior to that 21-day filing deadline, I did file a motion for reconsideration along with the request for judicial notice, a motion to compel arbitration, and a motion for the court to correct several clerical errors. So as a result, a filing extension is no longer needed for the motion for reconsideration. The motion precipice submitted instead requested that a review and decision on the 3 motions that were filed on March 25th be provided today.
Ms. Dillow, your response.
Your Honor, our issue with the motion was more so the defendant attempting to extend the time for filing the motion for reconsideration, as there's really no basis under the court rules for that request. But the defendant having filed her motion for reconsideration already makes that part of the motion moot. I don't have any specific other request in regards to the defendant's request to have the court respond to her records request.
All right, this is the ruling of the court. The motion for reconsideration is going to be denied. You failed to demonstrate palpable error. What you are attempting to do is relitigate the unsuccessful motion that you filed in 2014, attempting to attack the jurisdiction and validity of the underlying judgment. In regard to the motions for review of the pleadings in relationship to the motion for the ex parte order related to the renewing of the judgment, the court is going to, here we go. The court is going to deny that motion as futile. These motions are done ex parte and also under the ground of impossibility. We can't get you into the court at this time. So all 3 of your motions, excuse me, are going to be denied. Ms. Dillow, send me another 7-day order. And you, of course, have an absolute right to appeal my decision. You are attempting to, excuse me, I'm talking now. You are attempting to relitigate the question of the validity of the underlying judgment. That was something that we decided when you brought your motion to set aside the underlying judgment, and it was denied. You did not file an appeal. You did not file a motion for reconsideration. Instead, 5 years later, You're now attempting to revisit those things indirectly. You may not do indirectly what you may not do directly. Ms. Little, I'll look forward to your orders. You have an absolute right, Ms. Montgomery, to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you both for your time.
Your Honor,
Yes, ma'am.
you stated that there was a motion filed in 2014 that was denied. I don't recall filing a motion in 2014. In addition, the motion to compel arbitration is dealing with lack of subject matter jurisdiction of the court in regards to the arbitration clause that is in the contract.
Ma'am, there's a
So,
judgment here. So don't you understand that? There's a judgment here. You cannot now, after the fact, attempt to attack the judgment and say, I want to use an arbitration clause in the judgment. That's too late.
The arbitration clause in the contract,
Excuse me, I spoke.
excuse me, Your Honor,
I spoke.
Your Honor,
Excuse me. I didn't.
Uh-huh.
Your motion to set aside the default judgment was denied in May of 2016, not in 2014. May 25th,
Okay.
2016 specific. Okay, thank you. We're off the record.
Your Honor,
Ma'am?
yes, for the motion to compel arbitration, has the court taken a look at the arbitration clause in the contract terms that were submitted by the plaintiff?
Ma'am, I did my job.
Yes.
I reviewed the file. You are attempting again. I don't know how much more clearly I can make this. There was a judgment entered against you, ma'am, on the contract where you say there's an arbitration agreement. Your motion to set aside that judgment, ma'am, was denied. You may not now come back and say you want to arbitrate. There's a judgment already.
Okay, and has the court taken a look
We're off.